immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to today's webinar edition hosted by immigrationquestion.com, a networking platform where immigrants, families, advocates, and licensed immigration attorneys come together to understand U.S. immigration policies and procedures better. My name is GB Situsa, and I'll be your host for today's important discussion, Defending Against Deportation, the forms of relief available in immigration court. Now, getting a removal order from immigration authorities or being placed in removal proceedings is one of the most stressful moments an immigrant may face. Now, questions about family, employment, future opportunities, and the possibility of remaining in the United States begin to arise. However, many people are surprised to learn that being placed in immigration court does not automatically lead to deportation. Immigration law provides several forms of relief that may allow eligible individuals to remain in the United States, depending on their circumstances and immigration history. Now, to help us break things down, we are honored to be joined by attorney Natalie Driver Womack, a Virginia-based immigration attorney who provides comprehensive legal support to individuals, families, and businesses throughout the immigration process. She helps clients address difficult immigration matters while pursuing the strongest legal options available under the law. Attorney Driver Womack, thank you so much for joining us today. We're thrilled to have you for this important discussion.
I'm very thrilled to be here. Thank you.
Before we begin, a quick reminder to our audience, immigrationquestion.com is a public educational and networking platform. The information shared today is for general informational purposes only and does not constitute individualized legal advice. If you're joining us on Facebook, YouTube, LinkedIn, or any other platform, welcome. Please subscribe and share this session with anyone who may benefit from learning about immigration court proceedings and forms of relief that may be available in removal cases. Now let's dive right in. Attorney Driver Womack, to begin, what are the most common reasons individuals find themselves in immigration court?
Okay, sure. So I think that's a great question. And I always like an acronym because an acronym kind of like helps you organize things and think about it even when I'm not sitting here telling you. So the acronym that I have is CODE. Okay, so in immigration world, like it can be very complicated. So just think about the word code. All right. So the C stands for a criminal conviction. So let's say if you have been convicted of a crime, and if you were convicted in the crime in the past, and you have information with the fact that you've been convicted of this crime, this can impact your immigration status. Okay. So that's one of the biggest things. Not all crimes. Okay, but there are certain crimes. So that is the first thing. Then the O is for an overstay. And as you see, in May of this year, there was information that was submitted by Department of Homeland Security, and it was a memorandum that changed the policy with how they dealt with overstays. So if you have an overstay of a visa, that can also be an issue. Also under the O is also if you have an order of removal. And that means that you've been through the immigration process and the court has determined and the judge has determined that you can and should be removed from the US. Okay. Then the D. The D is the one that I think individuals are sometimes the most surprised by, and that's the denial. If you get a denial of a USCIS submission of a package, let's say if you do a marriage-based package and it's denied, that denial can be followed by an NTA. And an NTA means a notice to appear, and that is what puts you from USCIS application process to immigration court, and the stakes are higher. Okay, so that's the C, the O, the D, and the E. The E is dealing with encounters. Okay, so your encounters, that means dealing with the fact of how you've come into the US. If you've come without admissions and inspections, that can be an issue. Okay, and another aspect is your encounters with police. So let's say if you don't have a criminal conviction, but let's say you're driving and you have a suspended license, or you're driving and you're speeding, or you're somewhere and you encounter the police and they run your name. If they run your name and there is an order of deportation or something in the system that allows them to know that your immigration status is in question, that can have it to the result of you being detained. So again, the acronym is CODE: criminal convictions, overstays, denials for anything dealing with the fact of what you submitted to USCIS, and E, dealing with your encounters with the police or your entry into the country.
All right. Thank you for that, attorney. So what is the first next step when someone receives a notice to appear, also known as an NTA?
Right. Okay. So the first step is the direct opposite of what you want to do. Okay. The first step is don't panic, because when you panic, you do absolutely the worst things. Okay. So that's also if you were to encounter immigration, if you're out somewhere, again, if you panic and you run, that gives what is called fervent. They think that there's a reason to chase you. Okay. So again, the first thing, if you get a notice to appear, is to not panic. Okay. And overarching, there's going to be two areas that I think it branches off. But in reality, if you're in the world where you could potentially have an NTA, there are two things that I think that you need to think about. Okay. So the first thing is that you need to have an emergency contact, family, a friend who knows your A number. And an A number is your alien registration number. It's similar to what US citizens have as their social security number. It unlocks all information that's specific about an immigrant who is in this country. Okay, so have an emergency contact, know who that is, and they have your A number. That's the first thing. Now, the second thing is making sure that you think through the process. If you know that you potentially have issues with immigration and you have children, or you're the caregiver or the caretaker of your family, then you need to start thinking through, right? What would happen if you didn't pick your child up from school that day? What would happen if you couldn't go home to take care of your mom or your dad, to feed your mom or dad? Have things in place. Now, on a sophisticated top level scale, I would say have a will, and then have procedural based things that would happen in the event that certain things would happen to you. Like, again, you would have a will, you would have areas of custody, dealing with custody and custody for your children, who would pick them up, who would now be the caretakers. The same thing for your parents. But if you couldn't do that, right? Because I understand that also takes a financial obligation to handle those things. Talk to your family members. Say, look, if I don't call you, or if I'm missing and you cannot find me, or something is going on, here's what needs to happen. Someone needs to go pick up whoever it is at school. This is their pickup time. This is the counselor's name. Okay. Have those things in place. Someone needs to go feed mom at this time if I am not there at a certain time. Have those things kind of in place if you can't have those legal things in place. Okay, so that's the first, whether or not you are detained or non-detained. All right, so an NTA, again, that's the notice to appear. And it's a document that's going to tell you that the US believes that you should be removed. Again, this is a document that's alleging what the US thinks, but they have to prove it. There's due process, okay? So if you are detained versus not being detained, it's a whole different world, okay? So we'll walk through the easier side is if you are not detained. If you're not detained, you're gonna get a letter. It's gonna tell you that you should appear. The first thing that you need to do is consult with an attorney, especially under this administration. Okay, even if you are, you don't know who to contact, this is the reason why immigration question is here. It connects you with attorneys with your situation. And those attorneys will help you to at least start that process to figure out, here's what this is, here's what you have to make sure of, and here's the date that you have to be there. Okay. Now, if you're non-detained, again, you're looking at that, you're consulting an attorney. The second thing that you do is you make sure that you are so aware of that court date, where the courthouse is. Don't be late, and don't put your head in the sand and act like it's not happening. Okay. And the reason is because there are very harsh ramifications. The harsh ramification is, at a doctor's appointment, if you don't come, the biggest thing is maybe they'll send you a bill, right? That's the ramification. For this, that is not the case. Okay. So do not put your head in the sand. You have to realize that if you're getting an NTA, that means that you must appear. If you do not appear, they will issue an order in absentia. And that means that that order stands unless you are quick to realize and start a whole legal process to undo it. And I'm telling you, you can go through that process, but that is not where you want to be. You want to preemptively strike at any time that you can. The first preemptive strike is realizing, if I am here in this US and there are some issues, preemptively strike by already making plans that if something were to happen to you. If you get that NTA, then the first preemptive strike is you consult an attorney, you make sure that you have everything lined up, start getting all immigration papers. If you have paperwork that was with immigration court and it was old, make sure you have that for your attorney. If you have things with USCIS, have that with your attorney, okay? You have to give to your attorney, I apologize. And then the second aspect is if you're detained. This is the harder process, okay? So, and this is when time is everything, okay? So if you're detained and you're in the city or county or state jail, okay? It is very important that you connect with an immigration attorney as soon as you can, because they're gonna say, do you wanna pay a bail and all these things to get out of the city or state or county jail that you're in? Save your money, especially if there's an ICE hold on you, okay? The best thing that you can do there is to make sure that you're connecting with your attorney to get paperwork signed so that the attorney, when you go into the detention facility, that we can get to you, that we can say, hey, my name is Natalie Driver Womack, I represent blah, I need to come in and handle this. I can start talking on your behalf. But part of the disconnect and part of the hard part is being able to connect with the individual once they are detained. So that's one of the biggest things that you can do. Make sure if you can't get that attorney immediately, have a family member who's working on that for you, that emergency contact, okay? So also know that when you're there, you wanna make sure that you're thinking about like, that NTA will let you know whether or not you have the potential of asking for a bond, okay? And with that bond, you would have to make sure that you're gathering evidence. And there's certain instances where individuals can be detained and immigration court will not have jurisdiction. You may have to go to the route of dealing with a federal district court, and that can be done. But you have to have conversations, you have to talk, you have to have an advocate for you that's outside of the detention facility that can immediately start talking to your attorney for you. So those are the main things that I would say is just, don't panic, but you have to now effectively prepare. You have to realize that inaction will result in an order of removal, and it's hard to undo at that point.
Yeah. Now, what are the primary forms of relief that may be available to someone facing deportation?
Okay, so there are a lot of forms of relief, and I'm so glad that you asked this question because, and you hit on it in the beginning of your intro, is that, once you get that notice to appear, I know emotions are running high and individuals are scared and they're thinking that it's going to go fast, okay? If you are non-detained, it won't go as fast as if you are detained. Now, remember, I told you, on the side of being detained, speed is everything. You need to make contact because that can happen fast. Okay, I'm not lying. That happens very fast. So you need to move quickly there. If you're non-detained, you can now realize that there are things that you can do, detained or non-detained, but you have more time. So one of the first things is if you are, if you are here in the US and you have an attorney and you're looking at your situation, you can do voluntary departure. So that can sometimes be an option because some of the bars, meaning the preventions of being able to come back into the US, are not applicable to you. So you could eventually come back. Okay. So a deportation is different than if you voluntarily depart. So that's one of the first forms. Another form is that if you have a family relationship where you can adjust your status, you can also do that. Also, if you have been the witness of a crime, you could potentially do the U or the T visa. Okay. Another option is VAWA, and that's the Violence Against Women's Act. And it's a misnomer because it's not just for women. So if you are an individual who has been abused by a family member, and that family member could be your spouse, a significant other, or it could be a parent, it could be someone who is a US citizen or a lawful permanent resident, and they've used your immigration status as leverage over you, you can now self-petition. And one of the ones that's, I think is so important and not a lot of people talk about is the SIJS, which is the Special Immigrant and Juvenile Visa. So if you're under 18 and you can prove that you're in the US, even if you've come in illegally, because that's usually the problem with a lot of trying to adjust your status is coming in illegally. But if you're a child under 18, you've been abused, abandoned, or neglected, and we have an order in state court that says so, and now someone in the US has custody, that child can self-petition for themselves. So that is a very, very powerful visa that I think that a lot of a light should be shown on for young kids. So that is an option for children. And then there's two others that I think that are very important, is that's the cancellation of removal. And cancellation of removal, whether or not you're a lawful permanent resident or whether or not you came in the country illegally, you can prove certain things that you've been in the US and you can show your presence for either 5 or 10 years, and that you have a good criminal background, there's no issues, and that you have connections to the US that are significant. Then you can eventually, and you can deal with getting your citizenship through the cancellation of removal. So there are very powerful options that are there. There's even some that I still have not even, went through, but there are various options that are there. But you want to make sure that you're doing that first step of consulting with an attorney to tell them about your life, tell them what's going on, and see what your options are, because it could unlock citizenship.
All right. Now, can an individual qualify for more than one form of relief at the same time?
Yes. And I consider, how you say throw spaghetti at the wall, it's throwing several things of spaghetti. Like you're doing everything you can, right? So you're talking to your client, you're making sure, trying to see what benefits exist, okay? And what potential claims that they may have. Some may take longer than another. For instance, like a 601 may take longer, but you could potentially do cancellation of removal and not deal with that time. And you could get your adjustment of status via the court systems. So there's so many different ways that you can potentially obtain citizenship, but it has to be situationally specific to your life. If it fits, then you can now potentially have forms of citizenship. And there's also things, if you are in immigration court, that's like a temporary, or an option is, temporary protected status. So that's one that we didn't even talk about, but that is something that is there, but it requires that conversation to kind of see what you may be eligible for.
All right. Now, when may an adjustment of status become an option for someone in removal proceedings?
Yeah, so like life scenarios and situations can prompt that. So it could be the fact that initially when you came into the country, maybe even when before you were detained, maybe that family relationship had not, wasn't viable at the time, meaning maybe you did not marry the person, but now you're married. So someone who maybe came into the country and there was an order of removal on you, and that order of removal is there, but in that meantime, you've married someone. So again, you could adjust your status then. Also, in being in the US, I've seen there's instances where individuals, they have potentially tried with marriage, and as a result of trying with marriage, maybe it doesn't work. And part of not working is because there is some form of domestic violence. And again, individuals have to be aware that domestic violence is not just physical. It can be emotional, it can be financial. There are various forms of abuse. But again, that is actually having a conversation and talking with someone. But there are so many different options that may be available for your particular situation.
Yeah. Now, attorney, for someone currently in immigration court and worried about deportation, what practical steps can they take to better understand their options and build the strongest possible defense under the law?
So I think the first thing is to, building your defense means also like building your network, and that emergency contact is key, and I think, if you hear and you're here illegally, I don't think that you need to tell that to everyone, but I'm sure there's someone who is a confidant who you can let them know, as well as provide them with important immigration paperwork. And if not immigration paperwork, giving them your A number, okay? Because that A number, again, it unlocks so much for an attorney. So that's very important. Another thing that they can really do, again, that we talked about, is making sure that you have an emergency plan in place, right? And I also talk about in the past, and I've talked to different individuals about having what's considered a go bag. And a go bag is if you know your immigration status and you know that maybe you have a crime that is a deportable crime, have what is considered a go bag. And that go bag, so that if you happen to be deported, right, then you have materials with you so that you're not somewhere stranded. No one wants to play out the horrible what ifs, but in these situations and at this time and at this stage, you would do yourself a disservice not to play out all your what ifs. Another thing that you can do also is I've had a lot of individuals who contacted me. If they are concerned, then what they do is they obtain an attorney prior and in the event that they were ever detained. Because again, it is harder to get to you once you're in the facility. And for individuals who have contacted me beforehand, what we do is we do a FOIA request so that I don't have to run around and try to figure out what your status is, what you applied for. It's already there. I will have your file. Okay. So again, a FOIA request, if you do that, and a FOIA request is the FOIA, and that's the Freedom of Information Act. Everyone is entitled to information about themselves that the government has. So this this allows your practitioner to know everything there is about you and your situation and your immigration standing. So that is, again, fundamental. And, attending things like this, practitioners, like things are happening daily. Like we talk to each other, like, did you know this happened? Did you know this happened? Right. So if we are perplexed, then I'm sure individuals who did not decide to do this as a profession is perplexed. So staying aware and staying updated and attending these types of webinars, it keeps you in the know. So I think those are the most important things. Knowledge is power, making sure that if something happens, you don't panic, you just prepare.
True. Thank you so much for those insights, attorney. For everyone watching, the conversation about defending against deportation is not meant to create false expectations, but to provide information about processes that may affect individuals and families across the country. Immigration court cases involve important decisions that can shape a person's future. Now, having access to reliable information can help ask the right questions. It can recognize available options and can make informed choices about their circumstances. Now, if this is your first time joining us, welcome. Immigrationquestion.com is a networking platform where users can ask immigration related questions at no cost and engage with participating attorneys. We're also proud to share that immigrationquestion.com is BBB accredited and ISO certified. This reflects our commitment to transparency, accountability, community education, and security. Attorney Driver Womack, based on your experience with this platform, how does immigrationquestion.com help immigrants and immigration attorneys like yourself?
I think the most important thing that Immigration Question does is actually two. There is a care that is exhibited by all of the employees that even I've encountered. There's a care that they want to help. And in caring, they're able to connect two different areas of the world, individuals who need assistance and individuals who can assist. And when you add the level that someone is actually caring, hearing you, and actually trying to connect you to individuals to help, I think that that is what is exceptional and amazing about immigration question. Because I think, especially with the internet, you're kind of wondering, like, who do I connect with, who's going to help me, who's going to do the best. And I have dealt with various companies, and immigration question by far is the best for simply that they care and they actually are able to connect individuals.
Thank you so much for those thoughts. Now, before we move into our live Q&A, let's tackle an important question. What are some misconceptions that about the deportation defense and immigration court relief that you believe individuals should clarify in order to avoid any misunderstandings?
So, what I have seen is um, individuals will consult with each other and they will say, I had this happen and this was the result. This happened and this is the result, right? So, especially if the individual is detained, they will think that my situation is parallel to this, so the outcome should be this. And that is a huge misconception. You need to realize that everyone's case is individually specific to that individual. They walked a different journey than you. There's different things that exist. Now, another aspect that also matters is the practitioner who is working for you. Okay, so the practitioner who's working for you needs to be in the know. They need to be aware of the various things that are going on. And the combination of the two is what gets you results, not the fact that you think that your situation is parallel to someone else. That is one of the biggest things that I have seen, that individuals parallel their situations and they think that, oh, mine should work out this way. Also, another thing is timing, right? I have to prepare my clients that anything dealing with immigration will take time, right? Where I see things more expeditious is when you are detained, right? But even that is not moving at rocket speed. No matter what, you're dealing with the federal government. They have to make sure that due process rights are not violated. And sometimes if you sit there and don't say anything, your due process rights can be violated. But it takes time for the process and the churn of government. So again, comparing your situation to someone else's and thinking that it should work out this way, you need to have someone to look at your information specifically so that they know, and also that it just simply takes time and your attention. You, again, do not put your head in the sand. You're going to have to also, don't panic, but make sure you prepare and you do what you need to do.
If you're just joining us, we've been speaking with immigration attorney Natalie Driver Womack on defending against deportation, the forms of relief available in immigration court. We are now moving into our live Q&A session. This is your opportunity to ask general questions and hear educational insight from a licensed immigration attorney, pardon me. Now, please drop those questions in the chat or call us live at 516-703-3483, and we'll take as many as time permits. Temi Topi is asking, what is cancellation of removal, and how do I know if I qualify for it?
Excellent question. I'm very happy about this form of relief. Okay. So cancellation of removal is triggered when you're in removal proceedings. Okay. So that means that the court is looking to remove you, but you can say, no, I want to cancel this removal process because I can show, and there'll be a list of things. First, you have to determine whether or not you are a lawful permanent resident or whether or not you're here illegally. If you're here illegally, it's going to require different elements. If you're here legally, if you have a lawful permanent resident, it will require different elements. The only main difference is proof of time that you have to show that you've been in the US. So you have to prove your presence in the US under both whether or not you are a lawful permanent resident or an illegal entry. Okay, you have to prove that you've been here for a certain amount of years. You also have to prove that you do not have a criminal history. And again, the specific crimes will matter. Okay, so I don't want people to think like, oh, I have an assault and battery, so I'm not going to qualify. No, it depends, right? You have to look at all of it would be pulling your whole full background to see what crimes you do have. Okay, if you have any. All right. And then the next thing is to show that you have a connection or that a US citizen or lawful permanent resident would be harmed if you were to leave. Okay. So those are the criteria that you would have to prove. And if you can prove that, then you can qualify for cancellation or removal. And that's an amazing, amazing remedy that is available. I hope that more people take advantage of that particular visa option. Prayer of relief that is available.
Yeah. All right. Danielle is asking, how can I prove that my US citizen child or spouse would suffer exceptional and extremely unusual hardship if I were deported?
Wow. I love this question because I can tell the person is very well versed in just simply how they have written the question. So great question. I can tell that you're situational aware. And one of the main things that we would do is we would look at your child, right? And the child's life in this country versus what the child's life would look like if you were to have to leave, right? And what life would look like in this new country. Okay. So also sometimes if your child has potentially a learning disability, maybe in the US, the ability to handle that learning disability is better than it would in the country that you were to go to. Let's say if the child is sick or needs special attention, asthma, various things, maybe the level of medical care is not the same. Okay. Another way that you can also prove this exceptional hardship, unusual hardship would be is doing an evaluation. You can do a medical evaluation and you can actually be seen by a doctor, and a doctor would be able to walk through and kind of talk to your child, talk to you, and then they would be able to give a medical look at what they see the changes would be or the ramifications would be for your family if you were to have to uproot and leave. Because again, this harm is not just what people can physically see. It can be emotional and it could have a ramification on you and that child. And really what we're looking at is the child. How would the child be harmed if you had to leave or if the child had to be displaced? So there's lots of things that you can prove, lots of things that you can go into. But again, it would require knowing more about you and your child and your life and the country that you would have to go to if you were deported. But great question.
All right. Question from Ahmed. What other forms of relief are available if I do not qualify for asylum?
Okay. So there's conventions against torture and there's also withholding of removal. So it becomes a step down in the proof process, but you could also qualify for those if you were not able to qualify for asylum. And again, when we're dealing in individuals who are applying for asylum and you're in the court systems with asylum, this is a claim that we see it's harder to get forms of relief for, but it doesn't mean that it's impossible.
All right. Now, attorney, recent reports show that ICE has made more than 800 arrests using information obtained through airport security screening data. Should immigrants be concerned about how travel could affect their pending cases, and what practical steps can they take before making travel plans?
Yes, so it definitely should affect your travel plans. Okay, so I've had several people call and ask, I have this booked and I'm planning to go here. Should I go? And again, I hear the want, I hear, leading me to tell you, yes, it's fine. But in reality, what my first thought is, like if you're calling me just as a consultation, I'm evaluating what you're saying, right? And then trying to give you an assessment. But if it's my client, I will call my client and be like, listen, I do not want you to leave here, right? And here are the reasons why, okay? Now, standard, if you have anything pending with USCIS, for my clients, I do not want them to leave the country. Okay. I don't want them to leave the country, but if they're doing domestic travel, it's a little bit different. The form of how they're applying and what their status is in the US depends. Okay. But now, if you're telling me that you have something pending and that you want to go outside of the country and you're not my client, I'm still going to tell you, I think that this is a potential of a problem. Okay. Now, another aspect is this country that you're traveling to or on the ban list? And are you from a country that's on the ban list? All these things will matter. Okay. Now, if you have something that's pending and you travel outside of the country, if you try to get back in the country, it could be an issue if your petition was denied. You're not going to be able to fight that petition. Fight the denial as if you weren't in the country. Now, when you're dealing with domestic travel, the reason why this can still be an issue is because when the systems are going through and they're checking, they're not just individually running the system for TSA. TSA and DHS are working together. So you have to be very aware that those systems are now interlocking. And if there is an issue with your name, you may not know, right? And or something that you may have thought for years ago was not an issue, it can potentially be an issue. So again, I think it's very important for you to be situationally aware to what potential status you are in with USCIS. If there could be an order of removal for you, you need to make sure you are very aware. Now, I've given this number before and I've talked about this. There is a number that you can call, and there you can go online and you can look up immigration court hearings and immigration court orders. Okay. And when you're going online and you're looking, you would put in your A number. You put in your A number to ensure that there's not an order of deportation against you. And I think that's very important. Okay. So that's usually always one of the first steps that I do with a client, because if you moved and didn't tell USCIS or you didn't tell immigration court and they have an old address for you, they could have sent to you a notice to appear. And again, like we said before, if you do not appear for a court case, they can order you removed in absentia. That means ordered you removed in your absence. And that stands. So that's why it's very important to keep everything updated, to be very aware of what you're doing, and know that traveling is different now. So you have to be very situationally aware to what your situation is and whether or not you're going to travel domestic or international.
All right. Thank you to everyone who joined us for this webinar edition. And thank you, Attorney Womack, for sharing your knowledge and practical guidance with us today.
Of course. Thank you.
You can always visit immigrationquestion.com to ask immigration-related questions, stay updated or informed on those policy updates, and register for upcoming live events. If you missed any part of today's important discussion with Attorney Driver Womack, the replay will be available on Spotify soon. Just search Borderless Talk by immigrationquestion.com. We look forward to seeing you on Wednesday for our next live session. Until then, stay informed, stay prepared, and stay connected. Bye-bye.